Law Watch. Coleman Jackson, attorney and counselor at law. Welcome to Law Watch. My name is Coleman Jackson. I am an attorney at Coleman Jackson PC, a taxation, litigation, and immigration law firm based in Dallas, Texas. Our topic for today is employment authorizations for immigrants, who qualifies and how to apply. Other members of Coleman Jackson PC are Yulissa Molina, tax legal assistant, Reyna Munoz, immigration legal assistant, and Myra Torres, public relations associate. On this Law Watch video, our law firm's immigration legal assistant, Reyna Munoz, will be asking the questions, and I will be giving the answers as she and I will be discussing employment authorization for immigrants, who qualifies, and how to apply.
Hi everyone, I'm Reyna. I'm the immigration legal assistant at the tax litigation and immigration law firm of Coleman Jackson PC right here in Dallas, Texas. Now, attorney, this is a follow-up on a podcast that we did a couple of weeks ago where you and I were discussing green cards and work permits during this dreadful pandemic. Let's go deeper into immigrants and work authorizations in the U.S. First of all, what are the different types of work permits and who qualifies to work in the United States?
Well, Reyna, that is a gigantic question since there are over 50 or 60 different categories of work authorizations defined in the U.S. Immigration Nationality Act, or INA, 8 United States Code. Each of these categories apply to different categories of immigrants, non-immigrants, and their family members. Each category has different qualifying criteria. The duration for each category may also differ depending upon the specific authorizing provision of the INA. We might have to address your question in several separate podcasts over the next few weeks or even months. Interested listeners should subscribe to our podcast. For now, I intend to cover maybe 10 categories of work permits in this particular podcast. And for the most part, I will merely mention the technical references to the applicable INA section numbers and authorizing the particular work permit category. I'll also try to leave out the legal jargon and speak in ordinary language to see if I can explain work authorization so that normal people can understand the different categories of work permits and their specific qualifying requirements.
Oh, exactly, attorney. It's best to explain this in simple, easy to understand words so that people can follow along and understand what you're saying, I mean, talk in language that regular people can understand. And oh yeah, we can have a series of conversations on this topic in future podcasts. Anyone who wants to know more about work permits for immigrants can subscribe to our law firm's podcast. Okay, let's go. My first question is this. What are the different types of work permits and who qualifies?
I'm going to start by discussing those classes of immigrants who are authorized to be employed in the United States without restrictions as to location or type of employment. 1, an immigrant who is a lawful permanent resident with or without conditions pursuant to INA Section 216. These are immigrants issued Form I-551 or Green Card by the Department of Homeland Security. Number 2, an immigrant who is a lawful temporary resident of the U.S. pursuant to INA Section 245A or Section 210 of the Immigration Naturalization Act. These temporary residents of the U.S. have been issued an EAD or employment authorization document. Number 3, an immigrant who has been paroled into the U.S. under INA Section 207 as a refugee. Refugees in the U.S. have been issued an EAD or employment authorization document. Number 4, an immigrant who has been granted asylum under INA Section 208. Asylum seekers whose applications have been pending for more than 90 days can also be granted a work authorization while their asylum applications are pending decision at the asylum office. Number 5, an immigrant who has been granted temporary protective status, that's TPS, under INA Section 244 has been issued an employment authorization document, EAD. Number 6, any immigrant who has been granted U1 crime victim status pursuant to 8 CFR 214.4 are issued a work authorization so long as they are under that status. Number 7, any immigrant who has been granted VAWA status under the Violence Against Women's Act has the authority to work in the United States as long as they are in the VAWA status. All immigrants who are authorized employment incident to their status must apply to U.S. Citizenship and Immigration Services, that's USCIS, for work authorization with the exception of the green card holder and the immigrant granted VAWA status. A VAWA self-petitioner can request authorization to work directly on Form I-360 petition. And green card holders or lawful permanent residents have the authority to work anywhere in the United States. Again, all work permits discussed so far falls into the category where the immigrant can be employed in the United States without restrictions as to location or type of employment or employer. They can work anywhere. Now let's turn to the category of work authorization which are restricted as to location and employer.
So you mean some immigrants are restricted as to who they can work for and when? What kind of restrictions are we talking about here? You mean there are immigrants who can't work for anyone they want and anywhere in the United States they want?
That is exactly right, Reyna. Some immigrants are issued work permits that restrict who they can work for and where they can work in the United States. I'm only going to cover about 3 of those types of work permits in this podcast. These are the most popular types. But again, we might revisit this topic in future podcasts. For now, I'm going to limit my discussions of immigrants who are restricted by law to work for a specific employer or otherwise restricted to employment authorized in the INA to these 3 categories. First, a non-immigrant treaty trader in the U.S. under the E1 category and treaty investors in the U.S. in the E2 category pursuant to INA section 214.2E are restricted to working only for the treaty qualifying company through which they obtain their status. They cannot work for anyone else in the United States. Second, a non-immigrant student must have a valid F1 student status and are restricted pursuant to INA section 214.2F to working no more than 20 hours per week when the school is in session or full-time when school is not in session if the student intends to and is eligible to register for the next term or session. Moreover, the INA provides that students can engage in employment in the form of curricular programs such as internships, cooperative training programs, work-study programs, which are part of an established school curriculum. After being enrolled as a full-time student for a full academic year, these employment matters are handled on campus by the designated school's official at the student's college or university on Form I-20. Third, an intercompany transferee in the L1 status pursuant to INA section 214.2L is authorized to work only for the employee who filed the petition through whom they obtained the L1 status. An immigrant on L1 status cannot work for anyone else in the United States. I might add that the type of work they can perform is also restricted to the representations made by their employer in their petition. They must be high-level managerial or executive level individuals coming to the United States to oversee, to manage a specified area or provide specified expertise in growing the domestic enterprise.
Wow, attorney, thanks for giving such comprehensive overview of these 10 types of work permit categories. I have so many more questions, such as what is the duration of each one of these work permits that you have discussed, and whether the immigrant's family members, such as their spouse, children, and parents, can work too. And how can an immigrant with a work permit get a green card? We might have covered that in our previous podcast on green cards, but I can't remember your answer now. Maybe we can discuss those questions in future podcasts or blogs or something. But a big question right now with this pandemic deals with workers getting sick on their jobs. Question number 3 is, undocumented immigrants are not authorized to work in the United States. So what if they catch COVID-19 at work and get sick, or even worse, dies? Are they entitled to receive any money for lost wages or earnings?
That is a very complex question, Reyna, and the law could be in flux because of federal, state, or local rule changes being discussed in many circles today. These protections could impact whether employees can recover damages of any kind resulting from injuries allegedly sustained as a result of COVID-19 in the workplace. So I will limit my answer to Texas law pre-COVID-19. Well-established law in Texas says that injured workers and/or contractors are not required to be U.S. citizens, nor are they required to possess immigration work authorization permits as a prerequisite to recovering damages for lost earning capacity due to injury on the job. There is case law that establishes this principle going all the way back to the 1990s. But the law in this area could change as law catch up with legislative and other changes in federal, state, and local law as it pertains to the government's response to COVID-19. And let me just say, at this point, federal law can be an affirmative defense whenever it conflicts with state or local law. So bottom line, the answer to this question is unclear at this time, but it is a good question. Reyna, thanks for asking some very important questions regarding work permits. I know we did not answer all of the questions you might have on this very important immigration topic. We might revisit this question in future blogs, podcasts, or videos on our YouTube channel. For now, we have to go. This is the end of Law Watch for now. Thanks for giving us the opportunity to inform you about the immigration work authorizations in the United States. We might discuss other aspects of work permits and their requirements in follow-up Law Watch videos, Legal Thoughts podcasts, or blogs in the near future. If you want to see or hear more taxation, litigation, and immigration legal thoughts, podcasts, or listen to our podcasts or watch our videos from Coleman Jackson PC. Subscribe to our Legal Thoughts podcast on Apple Podcasts, Google Podcasts, Spotify, or wherever you may listen to your podcasts. Or watch our Law Watch videos right here on our YouTube channel. Stay tuned. We are here in Dallas, Texas, and want to inform, educate, and encourage our communities on topics dealing with taxation, litigation, and immigration. Until next time, take care. Law Watch has been a presentation of the tax, litigation, immigration law firm of Coleman Jackson PC, 6060 North Central Expressway, Suite 620, Dallas, Texas, 75206. 214-599-0431, Spanish 214-599-0432. Website www.cjacksonlaw.com.
Viendo Leyes ha sido una presentación por la firma de abogados Coleman Jackson PC, impuestos, litigación, inmigración, basada en Dallas, Texas. Estamos localizados en el 6060 North Central Expressway, Suite 620, Dallas, Texas 75206. Nuestro número en inglés es 214-599-0431. Nuestro número en español es 214-599-0432. Y nuestra página web es www.cjacksonlaw.com.